You have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs. For CR 4982, State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Cash bonds for the defense.
And are you Miss Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violate condition number.
Before we even hear a case number, listen closely to the judge's first question. This isn't small talk. This is the court zeroing in on risk, responsibility, and consequences. When drugs and pregnancy collide in a courtroom, every answer suddenly carries life-altering weight. Stay with this one because it escalates fast.
On or about the 22nd day of May 2025 in Bexar County, Texas, the defendant, Briella Butler, committed the offense of possession of a controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
I'm sorry, was that true?
True.
Thank you, ma'am. We'll waive the remaining violated condition, Your Honor.
Yes, no, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to 10,000.
Quick legal breakdown. Deferred adjudication is essentially a second chance. No conviction unless you mess it up. And here's the catch. Once a defendant pleads true to a violation, the judge can move straight to guilt and sentencing. No jury. No trial. One bad decision can flip the switch instantly.
$1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, state, what are you requesting?
The state is requesting adjudication of guilt and revoke for community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967, and we're also taking into considerations a county court at 2 case 2025 CC 011626, which is a failure to ID docs.
All right, in defense, what are you requesting? Oh,
Your
you
Honor.
can't sign that.
Well, this is the
This is, okay.
Your Honor, we're requesting that you continue her on probation, to deny the motion, and to follow the recommendation by probation to send her into the MIC unit or some other type of supervisory program with zero tolerance.
I really don't normally do zero tolerance in this court because being on probation, you're supposed to follow the rules. So my question for you, or maybe for her, what have you done? Because you've been on probation since February. What have you done? Have you completed? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Briella Butler.
What have you done?
I went to the 60 days NA or AA online.
And there it is, the word that changes everything. True. At this moment, the defense loses leverage, the state gains momentum, and the judge now holds all the cards. From here on out, this isn't about if there are consequences. It's about how severe they'll be.
Virtual visits, I reported twice.
All right, so that didn't work because you're here for a possession of controlled substance. What was that controlled substance?
Methamphetamine.
All right. So we know that doing the 60 days didn't work because you have a possession of meth. And how far along are you in your pregnancy?
7 months.
All right. So what that means is you're doing drugs.
No, ma'am, I wasn't.
Who did the meth belong to?
DeAndre Hartley. I have an affidavit that they just brought in.
Mhm.
It wasn't mine. I did stay at the scene when the cops came. My car, I just bought it. It was broke down, and
This is the moment the courtroom temperature drops. Meth use is serious on its own, but pregnancy adds an entirely different layer. Judges don't just see defendants, they see collateral lives. From this point forward, every ruling is about more than punishment. It's about protecting someone who doesn't even have a voice yet.
I was at my mom's house, and cops pulled up. And when they pulled up, my friend ran off, and they immediately put me in handcuffs and searched the car.
So let me just tell you right now,
And
the only way you're going to be continued on probation if you go into inpatient treatment. We're not doing this zero tolerance thing. So she can either go into inpatient treatment, and because you're pregnant, they will accept you at SafeP. But they're not going to accept you at any of the programs because of how far along you are in your pregnancy. So you can either do that or you can do the 18 months.
okay, thank you. Can I take my baby with me?
No, what ends up happening when you are at SafeP, because it's at the prison, when you're at SafeP and you deliver your baby, someone needs to be there to accept custody of your child. Otherwise, Child Protective Services will be picking up your baby and you will have a CPS case. And when you're released from SafeP, that's what will happen. You will have to do parenting classes and everything else that's required of you. And when you have somebody, if you have your mom or whoever it is to come pick up your child at the prison, they will make a determination on whether or not that person is appropriate or not. All right. So the court will deny the motion, alter and amend conditions to include SafeP. Probation, is there anything you recommend other than SafeP? I'm sorry, what? All right, so there'll be SafeP, and that's, of course, is in custody. And then it is 9 months. And you have to wait. What's the wait time for SafeP? I'm sorry, what? All right, so usually the wait time for SafeP normally is 3 months. So you'll be waiting at the jail for 3 months, then they'll transfer you to SafeP and you'll be there for 9 months. All right, so the court is going to deny the motion, alter and amend conditions to include SafeP. Once she is released from SafeP, she's to be placed on the MIC caseload, and there's to be no unsupervised contact with minors, field visits until further notice. She's to complete parenting classes. Court will take in consideration JN 7143967 and 2025 CC 011626. All right. Is there anything else?
Nothing from us, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, the court is calling 2025 CR 010368, State versus Devin Grisham. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Christopher Simpkins for the defense.
And are you Mr. Grisham?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Grisham, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the
We
indictment?
do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion is.
Mr. Grisham, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor, I did.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 011698. There's to be restitution to Quick Trip, QUIK Trip, and also to Walmart. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such
There
motions?
have been none.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours community service restitution, and no contact with Quick Trip or Walmart. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State Exhibit number 1 with all its
We have
attachments.
no objection, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that
Let's be crystal clear. This isn't mercy. It's a fork in the road. Inpatient treatment at safe or 18 months behind bars. Treatment sounds softer, but listen closely. This option includes jail time, a prison-based facility, and the very real possibility of CPS stepping in. This is accountability wrapped in hard reality.
defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we've asked that you follow the plea bargain agreement. Mr. Gone over the matter of Mr. Grisham. He is motivated to be successful. I would also ask the court to consider probating some of the community service hours if he obtains a GED and employment.
All right. Mr. Grisham,
Yes, ma'am.
it appears that you have a problem with taking things that do not belong to you. Why do you keep stealing?
I had a drug habit, ma'am, so it was kind of related to that. Before being incarcerated, I just actually quit doing drugs.
All right, what drugs were you using?
I'm methamphetamine, son,
How often were you using?
every day.
Okay. All right. Thank you for being honest with me.
Yes, ma'am.
Do you have any children?
No, ma'am.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's a $2,000 fine. That will be probated. In custody, the following. There's a referral to felony drug court. You need to be honest with them. That's a great program. They can really help you.
Yes, ma'am.
And there's to be a TAP evaluation in custody. If not accepted in felony drug court, then follow TAP recommendations. There's to be proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be restitution to and no contact with Quick Trip or Walmart.
May I ask a question, ma'am?
Yes,
Is that like just that Walmart or is that like in the
they
nation?
don't want you there.
Okay, so in the
Now, I will tell you, I will reconsider that once you've been clean and sober. You understand?
Yes, ma'am.
All right, there's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month until further notice, no residing in households with minors, and there's to be no unsupervised contact with minors. And take in consideration 2025 CR 011.
Notice the contrast. 2 defendants, same drug, very different outcomes.
Why?
Honesty, timing, and effort matter a lot. Courts can be harsh, but they're also strategic. Show accountability early and doors open. Ignore the warning signs, and those doors slam shut fast. The law isn't just about punishment, it's about patterns.
1698. State, is there any, I'm sorry, probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. In order to be successful, you need to communicate. If there's an issue and you feel like probation is not addressing it, you can always come back to me.
Yes, ma'am.
When you're accepted in felony drug court, and I know you'll be accepted if you are honest with them, what will end up happening is they will be in charge of your conditions. So the conditions that I've given you, those are for when you're in this court. But if you're accepted in a felony drug court, they may have different conditions that may be different from mine. They may say, no, we don't need to do field visits.